Hey there, Matthew Thrift here again with Berkshire Hathaway Home Services Seed and Joiner Realtors. In Greenville, we're going to be discussing the exclusive right to buy buyer agency agreement, SCR Form 130, that just came out January 1st, 2020 of this year. We've made some minor changes in the contract, so this is an update to the previous video that I made for the buyer's agency agreement. Again, some little changes in here, some little nuances to bring you all up to speed. Remember my disclaimer, not an attorney, strictly a broker in charge for the firm that I work for. If you work either for this firm and your broker tells you to do something other than what I say in this video, or you work for another firm and your broker is saying something other to do than I say in this video, please go by what your broker is telling you to do. That's who your license is under. That's who you theoretically work for. So please go by what they're saying. Again, here's another disclaimer. I am human. I am not God. I'm not an attorney. I am errant. So I can make a mistake. If you find that a mistake has been made in this video or something that I say, please kindly let me know. I will gladly take care of it and correct it, because that's what we do as human adults. So let's start out with Section 1. So Section 1 deals, and it's called the appointment of the broker. Basically, this becomes your parties of the contract. It's by this contract, and it's a blank line. So that is your buyer, your full buyer names, and then it appoints broker in charge of the brokerage name. It's not your name, it's not your broker's name, it's the brokerage name in that second line there as the buyer's exclusive agent. And I'm going to go down to the last line in the paragraph because we're going to need to know about what the word negotiation means in this contract. And it's simply explained here, the last line. Negotiation as used in this agreement shall mean property shown, negotiated, or information requested by buyer through the broker or through broker. So negotiation just doesn't mean taking a contract or an offer and writing it and going back and forth in a negotiation. It just means property shown or even information requested by the buyer through the broker. So I just want to make sure you're very well versed on that. It says the buyer agrees to conduct all negotiations for types of property described in Section 2 below through the broker. It's an exclusive right to buy. Basically, this is almost like a marriage agreement. You agree to work directly with the broker that they're signing with. So please make sure to point that out to your buyers. Other than that, there's not a whole lot. Read it. I'll say that throughout the entire video. Read this thing word for word, and when you want more information or to get a thorough understanding of it, come back and watch this video. But I'm not going to read every word in every section, just so you know. So I'm just trying to explain it to the very best of my ability. Let's go into Section 2. Section 2 talks about the purpose of the agency. Why is a contract even necessary for buyers and real estate agents? Well, this is what actually creates the agency relationship between the buyer and the brokerage, or agent out there. This document right here. So the state law, or South Carolina real estate law, says there has to be some things described in an agency agreement that make up this contract. One of those is the type of property that you're looking for. And in Section 2, it has 5 little checkboxes of the type of property that you're looking for this particular buyer. You have to have a general description, and you have to have an approximate price range. That's all in real estate law. So the general description could basically be so general as to say a 3-bedroom, 2-bath, single-story home in Greenville County, or a 3-bedroom, 2-bath home in Florence, or wherever you are. Basically, I'm in Greenville County, so I'll refer to the upstate just for sheer geographical purposes. But 3-bedroom, 2-bath, single-story home in Greenville, or 3-bedroom, 2-bath home in the such and such high school district. General description. And the approximate price range could be from $200,000 to $225,000. That's pretty self-explanatory. General location could also be in the city of Malden or in the county of Greenville, a general location. You don't necessarily have to put that in the general description. You can put it in the general location as well. Preferred terms would be if let's say they're a veteran and they want to use a veteran's loan. Say you could put the preferred terms would be on a veteran's loan, or if they're specifically looking for a USDA property, you can put that in there as well. Other would be they're looking for a house with a swimming pool. So you want to put some other stuff in there like swimming pool, fenced-in yard, or anything else that they may be looking for, just to remind you of exactly the type of conversation that you had and what they're looking for, so you can best help them in what they're looking for. Other than that, not a whole lot there. Let's go on to Section 3. Section 3 talks about the broker's duties as the real estate agent watching this. This is how you are going to perform for your particular client. And there's several things broken out here. And again, we won't read every word, but I definitely want to read A. It says the broker shall provide to buyer a meaningful explanation of agency and shall use broker's professional real estate knowledge and skills to represent the buyer in a diligent and effective manner and to locate property which is available for purchase or lease and suitable to the buyer. So say we have to provide that meaningful explanation of agency. What's that? The South Carolina Disclosure of Brokerage Relationships. Okay, you've got to do that. That is state law, but it's stating again here that's part of your duties. B, if the broker is not representing the seller, the broker shall represent solely the interests of the buyer in all negotiations and transactions regarding the acquisition of real property and repudiate any agency or sub-agency relationship with the seller or the company representing the seller, and shall not claim the sub-agency compensation offered to the selling broker in a multiple listing service. Basically, in our brokerage, we don't even allow sub-agency, so we're not even going to deal with that whatsoever. Okay, it's basically saying we're going to exclusively represent the sole interest of the buyer. It goes on in Section C, if you, as the agent, are representing the seller, that there must be disclosed dual agency. You have a form to fill out and sign for that as well. And it says you shall not disclose to the buyer information obtained within the confidentiality and trust of the fiduciary relationship with the seller, and basically vice versa. And then D, the broker may represent other buyers who may be interested in the same property as the buyer. Upon termination or completion of this agreement, broker shall keep confidential all information received during the course of this agreement, which was made confidential by written request or instructions from client, except as provided for under South Carolina law. Okay, if you do have a client that's interested, you have two buyer clients. If you have a client interested, there's something called the multiple buyer disclosure that you'll need to fill out. It's in zip forms. That doesn't happen very often, but it can. So make sure that you have that multiple buyer disclosure, and that even after the termination of this agreement, anything that you heard underneath the time frame of this agreement, you must keep confidential. So make sure that you're following ethics and state law on that. The second paragraph, broker represents the broker that they're duly licensed under the state laws of South Carolina. Well, if you're a member of the South Carolina Association of Realtors, you are licensed under the state. So we know that that's pretty standard. And then it says broker will use his best efforts as buyer's agent to locate property of the type described in Section 2 of this contract and to negotiate acceptance of any offer by buyer to purchase or lease such property. During the term of this contract, broker will give buyer information describing and identifying properties that appear to broker to substantially meet conditions set forth in Section 2. It's basically telling you, you've got the information, you've got the type of property, the general description, the price range, and you as the agent you're going to give that information as best as you possibly can to the buyer for them to make a decision upon what they're looking for. Other than that, I think that takes care of Section 3. Let's go on to Section 4. Section 4, buyer's duties and buyer agrees to. Now, if there's anything that you really need to be very specific when you're talking with your buyers and when you're presenting this document in front of them, this is where I would spend the majority of time with your buyer, because honestly, with being a broker for the past 8 or 9 years and then a regular agent before that, I think this is the section that most buyers have a hard time, and this is where they default. So let's let them see where they can default on this contract. It says, buyer agrees to, A, under section 4, work, and it's in bold, work exclusively with broker and its affiliated licensees during the term of this agreement by, and tells you how to work exclusively with them, by A, viewing any property or previewing only with the broker or broker's designated representative and not with another real estate broker, salesperson, or seller. That's A, number 1. Do not go out and cheat on me. We're signing this agreement. You only look at properties through me or my designated representative. Number 2, exclusively allowing broker or salesperson to identify property, negotiate for buyer, and otherwise to represent the buyer. Okay, that's pretty self-explanatory as well. And 3, referring to broker all inquiries received in any form from any other real estate broker or affiliated licensees. Anything that they get in the mail, telephone call, text message, email, they need to refer it back to you so that you can take care of that. Number 4, holding the broker harmless from liability as a result of incomplete, inaccurate information provided to broker or buyer or seller. Okay, so we don't know everything about every property that we're going into. Basically what this says is the buyer agrees to not hold me accountable or responsible for information about finding out incomplete or inaccurate information from another source. So there's a lot of protection in here for us. Number 5, holding the broker harmless from liability as a result of seller's failure to provide a complete seller's property condition disclosure statement. So if the buyer is looking at a piece of property and the seller's disclosure is not fulfilled, it's not the broker's responsibility. It's not, because that seller is fully responsible to fill that thing out. You know that we can't really touch those seller's disclosures. So it's not our fault that the seller did not fill it out completely. So number 6, indemnifying or paying for broker against all claims, damages, losses, expenses, or a liability arising from the handling of earnest money by anyone other than the broker. So that's a protection for us as well. If earnest money is being held by an entity other than our brokerage, which again this year Cedar & Joyner is really wanting all earnest money to be held at the closing attorney's office. We're trying to get away from holding earnest money because of problems. This is even reinforcing it, that you hold us not liable and you pay for our claims and damages or losses that we would suffer if there was a problem with another earnest money holder that had something go wrong. And let's go to B. Assist broker and its affiliated licensees in the process of identifying, negotiating, and contracting to purchase, lease, or otherwise acquire by, and it says number 1, providing broker with reliable information, including financial information and written authorization to obtain verification of funds that broker deems necessary for the performance of this agreement. So basically, this tells the buyer right here, we need all accurate information for your finances and how you're going to pay, and your accurate information from your bank account and things like that. If we need to provide that, it needs to be accurate. Please provide that to us accurately. And number 2, making himself available to meet with broker and to see properties in order that the broker will be able to perform the promises of the brokerage agreement. Okay, so if the buyer is not making themselves available when properties become available that they've identified in section 2, it's not the broker's fault. The buyer needs to make themselves available. Come on, they're buying a house. This is a very big decision. If you can't look at properties and they get lost or they get contracted on, don't be mad at me as the agent, or don't be mad at your agent because you didn't make yourself available because you continually were working. And even though that you knew it was a hot market, you did not make yourself available to look at properties. C, provide broker and its affiliated licensees the following information. The general nature, location, and requirements of the desired property. Well, they've done that in Section 2. And price range and other terms and conditions relating to the desired property. Again, they've done that in Section 2, hopefully. And D, to authorize buyer's attorneys and the settlement agent to furnish to brokers copies of the final settlement statement for the transaction prior to the closing date. So they're giving the attorney permission to provide us the seller's or the closing disclosure prior to the closing date, right in this document here. And on the bottom of each page, you have a set of lines for 4 buyers to initial, and then it says the broker have read this page. Well, as the affiliated licensee, you're able to initial on that page. If you're representing that buyer, you're to initial there to make it of executed contract between the brokerage and the buyer or buyers. Let's go on to Section 5. Section 5 is the compensation of the broker, and there's a few things in here that could have your buyer have a little bit of heartburn, but I'm going to try to explain it in a way that will be beneficial. Now, I'm going to start off by saying there is some there's a difference of opinion here between a lot of brokers and between a lot of agents in the way that we get paid. Okay, I have a difference of opinion just because of the simple fact of how litigious our society is and how personal this industry is. So I'm going to explain mine, but again, like I told you at the beginning of this video, if you find that your broker has told you something different and they want you to fill out something different, please go by what your broker has said. Okay, so compensation of the broker. Broker's fees will be deemed earned when buyer is under contract to purchase any property presented by broker or negotiated by buyer. Remember that word negotiation, it's found in Section 1. Okay, it's not just an offer written, it's property shown or information that the buyer requested on. So if they've requested information on that, that is also covered in here as well. This fee will be due and payable at closing or upon buyer's default. Okay, that's the first heartburn. Upon buyer's default. Buyers don't necessarily get comfortable with that. Okay, but there's ways to go around that and basically overcome that right there. If buyer defaults, the total compensation that would have been due broker will be due and payable immediately in cash from the buyer. Well, that's number 2 heartburn. You tell somebody that if you mess up, you owe me immediately in cash for the amount of money that I should have made off of the transaction. So in consideration of the services performed by broker under the terms of this contract, the buyer agrees to pay broker the following fees. Now, if you've made the mistake of telling your buyer at the front of your conversations that they will never have to pay you and that you get paid by the seller, and then you go to explain this document, that may be a very uncomfortable conversation that you're having. Okay? Now, most of the time, if it is a MLS type sale, you as the buyer's agent are getting paid by the selling brokerage, because remember, the selling brokerage was hired by the seller. The seller is going to pay the selling brokerage. That's their contract. And then the MLS agreement is between the selling brokerage and the cooperating brokerage. That's who's paying us. But if you've made the grave mistake to say you won't have to pay me, and then you come up to a for sale by owner or a property that's not in the MLS, there's a precarious situation there. So there are ways to go about that. There's ways to handle that when that does come up. Again, that's why there's so many differentiating opinions on this. But it says check and initial all applicable sections. I want to make sure that you understand that. Check and initial. So there's a line there. You check the box and then you initial those lines, or you have the buyer initial the lines that they want. Okay, now it starts off with A, the brokerage fee. Option 1, buyer shall pay broker a brokerage fee, which is the greater of blank dollar amount or blank percentage of the purchase or total lease price. Okay, what you can't do, and I've seen this in a few buyer's agency agreements, you can't put 2 to 3%. There has to be a defined amount that you are working for. It can't be a range. Okay, so I just want to make that point very clear. Okay, now again, there's some differentiating opinions on that. I don't care. There's got to be a defined amount that you set in this agreement of the purchase price or total lease price, renewable if applicable, of any property purchased or leased by the buyer, including for sale by owner properties. Now let's stop right there. If you have 3% in this agreement here and you don't find anything in the MLS and you take your buyer to a for sale by owner and your for sale by owner only says, well, that's fine, I'm only going to pay you 1.5%, I'm only going to pay you 2%, you got to be very careful of how this is written, or you're going to have to, A, if you're dead set on getting your full 3%, which, I mean, you should be, but if you are, then you're going to have the buyer pay that extra fee, that extra percent or that extra 1.5 that the seller is not paying for in a for sale by owner transaction. We'll discuss that in here a little bit more. It says, if within blank days after the expiration of this contract, buyer purchases or leases any property which broker has negotiated, there it is again, during the term of this contract, the buyer will pay broker the brokerage fee stated above. The broker shall use his best efforts to obtain payment of the brokerage fee out of the transaction. Okay, so let's stop there. It says, broker shall use his best efforts to obtain payment of the brokerage fee out of the transaction. Okay, so that's easy when you're dealing with a MLS listing. But if you're dealing with a non-MLS listing, let's say a builder, a new construction that's not an MLS, there's no compensation being offered. Or that, again, going back to that for sale by owner. If you can't get the full amount that you've asked for here, it states, we're going to try to get out of the transaction, but if we can't, buyer shall have the obligation to pay broker the brokerage fee set forth in this contract if broker cannot obtain payment of such fee out of the transaction. Any fees paid by seller or seller's agent shall be credited against the brokerage fee. Okay, so if you've asked for 3% and you get 2% from the for sale by owner, that's getting credited against that 3%, then therefore the buyer owes you the extra 1%. Now, I always ask people in live training, how many people would absolutely do that? Would they force their buyer to pay that extra money? And a lot of times I'll get a mixed crowd. I'll get some people saying, yes, I'm going to put that on the buyer's side. Or some people say, well, no, I'm not going to do that at all. Okay, so let's take, for example, a builder that's only paying 2%. But you've asked, if you have option 1 checked, you have 3% here. Are you therefore going to stick that extra 1% to your buyer? Again, some of you may, some of you won't. Some of you say, no, it's not worth it because I don't want to lose my reputation. Okay, and that's what it all boils down to. Are you going to fight this? And because we're such a personal relationship business, are you going to force this? And, you know, some people may, some people won't. This definitely is a good thing for the brokerage in case a buyer defaults on a brokerage or does something against the brokerage. If you have option 1 checked, it gives the brokerage the authority and the legal binding ability to take somebody and hold somebody accountable in a court of law. However, we don't see that very often. Matter of fact, I've never seen it. I'm sure it's been done. Matter of fact, I know it's been done. I know it's been done to an agent outside of South Carolina, but it may have been done here in this state as well, but I've never seen it. Now, I'm going to go to option 2, and I'm going to read it very plainly and clearly. It says, option 2, broker shall obtain payment of the brokerage fee out of the transaction. Broker shall be paid by the cooperating broker as stated in the multiple listing service or as agreed to by the broker and cooperating broker, or as agreed to by the broker and the seller in a for sale by owner transaction. The last line, buyer shall not be responsible for paying broker the brokerage fee. So if you have had that statement where you said, don't worry, you won't pay me anything, you may want to think about going with option 2. Now again, there are some brokers out there and some trainers that would say this is absolutely something that you really kind of want to stay away from because you don't work for free. Nobody works for free. Okay? I look at that and I go, if you're going to come up on a situation where you cannot get paid, most of the time whenever I've seen this, you can't get paid from a for sale by owner or something along those lines. Most of the time I have seen a buyer step up to the plate and say, you've worked hard for me, you deserve it, we'll put that in the transaction cost, or however we're going to do to get you paid. Okay, so that's the majority of times that I see this. There may be times where if you can't get the brokerage fee out of the transaction and the buyer says, no, I don't have to pay you, there may be times where if you check option 2 where you may have to say, I'm going to cancel my buyer's agency contract at this point because I'm not able to obtain it. And I'm not going to be able to fulfill my end of the bargain because my brokerage won't allow me to work for free, and that maybe have to be referred out or however that needs to be handled. Again, I've not seen that happen. It may have happened, but I've not seen it. Now, my personal, professional opinion is option 2, and I'm going to explain why. So since we've already said exactly what option 2 is, let's go back to the scenario of maybe a seller or a builder that's only offering 2%, and you have 3% in option 1. Okay, so that obligates the buyer to pay you the extra percent. Okay, we can go round and round about who's right on that, the buyer should pay, or you should just let it go. Okay, but what happens if you have 3% in here and you have a builder or a seller that's offering 4%? Some builders even offer up to 5% and bonuses. So I look at that and I go, well, if you're only contracting to charge this buyer 3%, and you're stating that you're going to get it out of the transaction, well, you're getting that and you're taking a whole lot more. Ethically, you should turn right around and offer that extra percent or that bonus to your buyer because of the fact that you told them you were only going to take that amount. So by this contract, theoretically, you can't take more. Now, can you amend this contract? Can the buyer agree to pay you in another contract, for example, for a bonus, as long as it's disclosed? Yes, they can. But if you accept more and they did not have the opportunity to challenge that or approve that or agree to that, theoretically, you could be in violation of your own contract if you said you're only going to charge them 3% and you took 4% and or a bonus on top of that and you didn't offer that back to them. Okay? That would be a very discouraging type of legal battle there in court when you're sitting up on a courtroom stand and you're saying, well, I only charged them 3%, but yet you took 4% plus a bonus. And you never offered that. They never even gave the authority that you could do that. Now, case in point, if you're in option 2, the way this is reading, whatever you're being offered, you can get it from the transaction. So there's not a percentage being offered, it's just whatever you're getting out of the transaction if you choose option 2. If they're offering you 3%, you can take 3%. If they're offering you 4%, you take 4%. If they're offering you 4 plus a bonus, you take 4 plus a bonus. Okay? Or if they're only offering you 2, that's it as well. You take 2. And you don't have to go and amend. You don't got to get an agreement signed. You don't got to get authority to do so. It's just whatever happens in the transaction you take. And then nobody's being threatened that they have to pay more just because the seller didn't offer you the amount that you were asking for. Nobody has to go and amend or correct this contract. So again, there is arguments that can be made on both sides of this. And that's kind of where I stand. Again, I've been told that I'm wrong on even feeling this way, but that's okay. I mean, that people are entitled to their opinion as well as I'm entitled to mine. But again, my preference, and check with your broker on their preference on this. My preference is option 2. Option 1 does leave it open for the company to have some legal ability to go back on a buyer if necessary. But again, I don't like to think that as agents we're going to go after our buyers for not fulfilling this area of the contract or not coming out of pocket for what you did not get in the transaction. Again, my opinion, if you don't agree with it, I understand, it's okay. Just go by what your broker has said. In section B, the buyer will pay the broker the following. Okay, let me just go on record here and say this is not something that our company encourages at all. We don't do retainer fees. We don't do service fees. Nothing like that. Now, is it illegal? No. It's just something that our company executives have said that they do not prefer, nor do they want to see in our agreements. Service fees being one of them. There are companies out there that they will charge a fee on top of what they're making in commission to pay for a transaction coordinator. And again, nothing by law is saying that that's wrong, but what can happen is if the agent is only being offered 3% and they want that buyer to pay that transaction coordinator fee of whatever it may be, that's coming right out of the buyer's hands. Okay, so they're actually charging these fees on top of what they're making. This particular section is pretty clear about the fact that the brokerage fee in section A, if you're only charging 3% in section A, option 1, that brokerage fee is supposed to be credited toward that service fee, not the service fee on top. So I want to make sure that everybody understands, if you're going to charge a service fee, that's to be taken outside of your brokerage fee that you're actually requesting your buyer to pay. It's not paid on top. So I just want to make sure that everybody understands that. But other than that, if you're with our firm, we do not push this particular section at all. As a matter of fact, if I was filling this out, I would almost ask the buyer to strike through this because we're not going to do this whatsoever. Okay, so other than that, that's really all I'm going to say in that section. Let's go on to section 6, term of agency. Section 6, the term of agency, is basically just your beginning and your end dates of the contract. We don't even need to spend a whole lot of time on this. You go under exclusive terms on such and such date, and it ends at 11:59 on such and such date. That's pretty self-explanatory. I don't even think we need to continue on. Let's go on to section 7. Section 7 talks about the consent to disclosed agency and designated agency. And the very first line there talks about the South Carolina disclosure brokerage relationships. It simply says, buyer acknowledges receiving an explanation of the types of agency relationships that are offered by brokerage and a South Carolina disclosure of real estate brokerage relationships form. Meaning, you provided them a meaningful explanation and you also provided them a copy of the disclosure of real estate brokerage relationships document. At the first practical opportunity at which substantive contact occurred between the buyer or broker and the buyer. So what does substantive mean? It simply is this. Basically, if you've moved past the point of talking about just generalities of location and different homes and how many kids you have and how long you've been married, but now the buyer is asking about the price of the home. They're asking you to look into it. They're asking how many square feet. They're really digging in. How many bedrooms? What do you think the utilities are about this home. Substantive contact. What do you think the lending rates are right now? Do you think that we would be able to qualify? Hey, let's go see that home because I'm really feeling interested. I really like the way it shows online, and my wife and I have talked about this, and we really want to dig into this house a little bit more. That is substantive contact and information being shared about real estate. So that's what they're looking for. Again, if it's just general information about the real estate market or somebody's children or whatever the case may be, how many children you have or how long you've been married, that's not really substantive contact over real estate. They're looking for that really deep down questions and advice on real estate and property. It says, buyer acknowledges that after entering into this written agency agreement, agent might request a modification in order to act as a dual agent or a designated agent in a specific transaction if asked. So you got two lines there, two for dual agency and two for designated agency. Remember, dual agency is if the buyer's agent is also representing the seller. So the second line there, permission to act as a dual agent, will not even be considered. Okay, so they're telling you this up front. If you have a listing that matches my criteria, I want to be represented solely by sole interest of my best interest. So I'm not going to let you do a dual agency. And they're telling you right up front. But it also says permission to act as a dual agent may be considered at the time I am provided with information about the other party to a transaction. If buyer agrees, buyer will execute a separate written dual agency agreement. So they don't really have to agree right now. They're just saying, if it comes up, at the time I'm presented with the information, I may say it's okay. And again, the same thing with the designated agency. Either they're not going to accept designated agency, or they're going to say, you know what, let's just wait. If it comes up, we'll discuss it then and see how we feel at that time. Other than that, again, the bottom of the page, you have for buyers to initial and the agent/broker to initial this page as well too. So I think we can move on to Section 8, other potential buyers. Section 8, other potential buyers, and this is pretty easy to understand, but we need to still go over it a little bit because there's some things I want to explain. It says buyer understands that other potential buyers have entered into similar agency contracts with broker, which may involve the purchase or lease through the broker of the same or similar property or properties as buyer is attempting to purchase or lease. The buyer consents to broker's representation of such other buyers. Broker agrees not to give buyers confidential information to such other buyers and not to give such other buyers confidential information to buyer unless otherwise agreed. Okay, so basically, let's go back to that property that you as the agent have two clients on that are interested in that same property. Whatever buyer A told you, you can't tell buyer B. And whatever buyer B told you, you can't tell buyer A. And remember, you have to have that multiple buyer disclosure to say, hey, you as the agent, I have two buyer clients interested in the same property. Everybody needs to know about it. And I want you to know, Mr. or Mrs. Buyers, buyer A, buyer B, that I'm not going to provide anybody else your information nor their information. It's going to remain completely confidential. I just want to make you very, very well aware of that. Okay, be very careful. Make sure you get that multiple buyer disclosure if this does come up. Let's go into Section 9. Section 9, indemnification of broker. It says buyer promises to disclose to broker whether buyer has signed any agency agreement with any other broker or has been given prior information about any property that is the subject of this contract by any other broker or salesperson, or has previously been shown any property by any other broker or salesperson. Okay, stop. Okay, you want to really, really get this point across to your buyer. Okay, they need to find out whether they've signed an exclusive right to buy, and there's some things about whether or not there was cause to have a buyer to leave a broker and then go with another broker, and they're the contributing cause to the sale or the writing of the contract. There's all sorts of things like that. I'm not going to get into that on this contract or on this video. Okay, not at all. There's not an over the threshold or whoever shows them the property first. There's not that. Okay, but my opinion If somebody automatically tells you that they've signed an exclusive right to buy, you need to stop what you're doing and you need to say, you need to contact that other agent or you need to contact the other broker. And if you don't choose to work with them anymore, you need to go through that broker or that agent and have them release that agreement. And you do what you can to get them to get back to that agent. That's just the right thing to do. Now, there's going to be people on here that are going to disagree with me because there are buyers out there that abandon people, that abandon other agents, they abandon brokerages, and I get that. So ethically, if that happens and all of a sudden a buyer starts looking in another location and they don't ever let you know and you don't have knowledge that they signed another agency agreement, theoretically you haven't committed an ethics violation. But if they tell you that they've signed another agency agreement, you want to stop what you're doing, get that release, and then if they want to continue to work with you, then take up the relationship at that point. But don't do it if they've told you that they have another agency agreement out there. That's just not something that you want to do as a realtor, and we live by the golden rule, do unto others as you would have them do unto you. Let's see. If buyer fails to tell broker about such other broker's or salesperson's involvement and broker incurs any loss or damage as a result of any claim being brought against him on account of such involvement due to no fault of the broker, which they would have no idea, then buyer shall pay broker all such losses and damages incurred by broker because of such claim. So basically, if the buyer doesn't tell you and you help them and all of a sudden the other agent takes you to court and you lose, it's the buyer's responsibility to pay all your court costs, all your losses, and the commission that you would have been having to pay to the other company. So that's pretty big. You need to explain that to your buyers. So let them tell you exactly if they have something. That's why I said you don't really want to get involved in this. This could be a very, very bad thing. And again, some people are going to disagree with me, but I just think if somebody tells you, send them back to that other agent. That's the right thing to do. If they say, I don't want to work with that agent, they never helped me, they never did anything, they never showed me properties, we just don't agree, then tell them to contact the broker in charge and let the broker in charge handle that for them. That's what I got to say about that. Let's go into Section 10, Disclosure. Section 10, Disclosure of the buyer's identity or / confidentiality. I just want to say that we really don't see a lot of this, of confidentiality being done in residential. This is done more in commercial, especially if other large companies are coming in. I won't say any companies on this particular recording, but large companies coming in, the company doesn't want people to know who's coming there. They could sign a confidentiality agreement. We really don't see this on the residential side. The broker does or does not have the buyer's permission to disclose the buyer's identity to all property owners and other third parties. The buyer is advised of the possibility that seller or seller's agent may not treat the existence, terms, or conditions of offers as confidential unless confidentiality is required by law, regulation, or by confidentiality agreement of the parties. Now, the one time that I did see this where a buyer wanted to remain confidential, when the offer went to the other side, the seller just basically refused to cooperate with the offer and basically started rejecting it until the buyer said who they were. Okay, so it kind of backfired on them, and finally the buyer ended up having to disclose who they were. So that's why I say you don't really see this in residential very often. Hopefully your buyer just is okay with you saying they do have permission. That's all I really got to say about that. Let's go on to Section 11, Broker Liability Limitation. Section 11, the Broker Liability Limitation. Now, if you notice on this contract, this particular section is written in italics. This is a section that can be very difficult to explain. And so we're going to do a little bit more reading in this section than any other section probably, other than maybe Section 4 in the contract. Because you really got to get an understanding of this to appreciate it and to be able to understand it to explain it. So it says, buyer agrees, broker provided buyer with benefits, services, assistance, and value in bringing about this contract. In consideration and recognition of the risks, rewards, compensation, and benefits arising from this transaction to broker, buyer agrees that he shall pay broker's attorney's fees and that broker shall not be liable to buyer in an amount exceeding the broker's compensation by reason of any act or omission, including negligence, misrepresentation, errors and omission, or breach of undertaking, except for intentional acts. So that's a whole lot of jargon to basically say this. If the buyer wants to sue you or take you to court, this contract is intended to protect you from not having to pay out anything more than what you would have made in the transaction to begin with. It says it won't exceed that broker's compensation. But it does say except for intentional acts. Now, if you go out there and you do something intentionally or willfully, this deal is off the table. If you just did something by accident, this contract is written to try to cover you. And I'm not going to sit here, I'm not an attorney, and say this contract will completely cover you in everything. I'm not going to say that at all. I'm saying it's written and the intent is to do that for you. This limitation of liability shall apply to all claims, losses, costs, damages, or claimed expenses of any nature from any causes except intentional or willful acts. We've already talked about that. So that the total liability of the broker shall not exceed the amount set forth herein. Again, it reiterates it. Buyer will indemnify and hold harmless and pay attorney's fees for broker from breach of contract, any negligent or intentional acts or omissions by any parties, inspectors, professionals, service providers, contractors, etc., including any introduced or recommended by the broker. The buyer agrees that there is valid and sufficient consideration for this limitation of liability and that broker is the intended third-party beneficiary of this provision. Basically, if I recommend a third party and they do something wrong, again, the buyer is going to pay and hold me harmless from what these third-party professionals do. Okay? I can't control what a home inspector is going to go inside a house and do. I can't control what a termite inspector is going to do. If they do something ridiculous or intentionally or willfully, I can't be held liable for that. At least that's what this document is saying. So again, just kind of get a handle on it. Just let people know, hey, just so you know, if I do something wrong, you think you want to sue me, this contract is only going to go for what I would have made in a transaction. And that's really all I would leave it at. It does say that you're going to pay my attorney's fees and everything else if you decide to sue me. Hopefully, we won't ever have to go down that road. Hopefully that's the case. Let's go into Section 12. Section 12, Non-Discrimination. It says the broker and buyer agree that all actions carried out under this contract shall be in full compliance with local, state, and federal fair housing laws against discrimination on the basis of race, creed, color, religion, national origin, sex, familial status, marital status, age, or disabilities. Listen, if you're going to discriminate, do not do it. Okay, just put it right there. I can't do it. You can't do it. It's against the law. It's against this contract, and it's not good if you're going to be a discriminatory person and have the realtor name behind you. So let's just not do it. Let's treat others as we want to be treated, and let's stay away from any discrimination whatsoever. Let's go on to Section 13. Section 13 talks about professional counsel. And this is a pretty easy section to understand. It says, buyer acknowledges that broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, home inspector, or other professional service provider. Buyer agrees to seek professional advice concerning the condition of the property, legal, tax, and other professional service matters. Okay, so let's make this really easy. You're being retained to talk to them and advise them on real estate. You're not being retained to talk to them and advise them on how a survey is. You're not being there to advise them on how and what type of deed they should do. You're not there to talk to them about their taxes. Okay, stay away from that kind of stuff. Stay in your lane. Okay, you're there to provide professional counsel on real estate related stuff. not something outside of your lane, which is exactly what this states. It's getting the buyer that across. Even the buyer asks you, what do you think about the taxes? What's the tax liability on me if I buy this house? Do not refer them to a tax person, please. Other than that, let's go into Section 14, mediation. Section 14, the mediation clause. It says any dispute or claim arising out of or relating to this agreement, the breach of this agreement, or the services provided in relation to this agreement shall be submitted to mediation in accordance with the rules and procedures of the dispute resolution system of the National Association of Realtors. Disputes shall include representations made by buyer or broker in connection with the services to which this agreement pertains, including without limitation allegations of concealment, misrepresentation, negligence, and/or fraud. Any agreement signed by the parties pursuant to the mediation conference shall be binding. The mediation clause shall survive for a period of 120 days after the date of the closing. So if there becomes a dispute between the buyer and the agent or broker, the National Association of Realtors has set up a mediation services through our local association to save people from the costly terms of litigation in a regular court of law. We have ombudsmen, we have people that are mediators here right in our local area. I'm sure that you do in your part of the state as well, to help mediate. Now, and it does say that any agreement signed by the parties pursuant to the mediation conference shall be binding. It means once it's done, it's done. It's binding. So you have that option. You have that ability to handle things in an appropriate manner through your local association, through the state association, and it's all designed by the National Association to make sure that people do not have to go to court over something basically that could be handled through mediators. Let's go on to Section 15. Section 15 talks about the sex offender criminal information. This is very easy to understand, and I'm going to make a point very clear. But let's read it first. It says, buyer agrees that broker is not responsible for obtaining or disclosing information in the South Carolina Sex Offender Registry, and no course of action may be brought against the broker for failure to obtain or disclose sex offender or criminal information. It says the buyer agrees that they have the sole responsibility to obtain their own sex offender, death, psychological stigma, clandestine laboratory, and crime information from sources, for example, law enforcement, private information, the web, whatever. It says the buyer may obtain information about the sex offender registry and persons registered with the registry by contacting the local county sheriff or other appropriate law enforcement officials. Basically, here it is in a nutshell. You're not responsible for obtaining it. You're not responsible for disclosing it. Let the buyer do this on their own. If you make a mistake and you say that someone in the neighborhood is a sex offender and they are not, you will be held liable. I highly discourage going down this road. Let the buyer do this themselves by contacting the proper officials. Let's go into Section 16. Section 16 it talks about the entire binding agreement. It says this written instrument, including the additional terms and conditions set forth on the reverse, expresses the entire agreement and all promises, covenants, and warranties between the buyer and broker. It can be changed only by a subsequently written instrument signed by both parties. Basically, it's no different than a regular contract for sale. This is a contract between the brokerage and the buyer. If it needs to be changed, use an addendum. Use a scratch-out initial. It can be changed, but it's got to be done in writing. It can't be done in verbal. Okay, so this is a legal binding agreement. So there's really not a whole lot to say about that. Let's go on to Section 17, which talks about contingencies. Well, Section 17 will be really easy to understand because you have blank lines there. You write in a contingency, and you say, well, what in the world can a contingency be on a buyer's agency agreement? Let me just give you a what-if scenario. Suppose a buyer comes into town from somewhere outside of the state, and they're looking to get a job here, and they're on a job hunt, and they're here to interview with the company. Well, if you sign a buyer's agency agreement with this person, you can actually write a contingency in there that if they do not get this certain job, that this contract becomes null and void. The buyer's agency agreement to be able to be fulfilled is only contingent upon if they get a job and they move here. Okay, that's one. I'm sure there's several other ones that you could probably think of. That's just one I thought of off the cuff. So let's go into Section 18. Section 18 is the facsimile and other electronic means section. And it says the parties agree that this agreement may be communicated by the use of a fax or other secure electronic means, including but not limited to electronic mail and the internet, and the signatures, initials, and handwritten or typewritten modifications to any of the foregoing shall be deemed to be valid and binding upon the parties as if the original signatures, initials, and handwritten or typewritten modifications were present on the documents in the handwriting of each party. So basically, if you use a fax, if you use email, if you use a carrier pigeon, whatever the case may be, it doesn't matter anymore. We're in 2020, and there's all sorts of ways to make a document binding once it's signed and initialed. So don't worry about the nuances of, oh, it's got to be blue ink and it's got to be wet ink and it can only be this type of paper, and don't worry about all that sort of stuff. We can use fax and anything else to make this a legal and binding document as long as it's initialed, signed, and dated by all parties. Let's go into Section 19. Section 19 is a new section of the buyer's agency agreement. Because of the age that we're living in, it seems like everybody or everywhere you go, there's a camera pointing in your face, kind of like the one that's pointing in my face right now. You're always under surveillance. Everybody has video camera. Everybody's got a phone, and people are now putting, next the Nest doorbell ringers and video cameras within their home. Now, by federal law, you can't put a video camera in a bathroom, even in a private residence. So just want to let you know about that. But who knows? There could be people that don't care about federal law, and there are. Okay? But it says, buyer is advised that properties they enter may have both audio and video surveillance. Broker advises buyer to be aware of the possible surveillance and conduct any and all communications about the potential property off-site. So, this is very self-explanatory. If you're walking through a house and you're looking at it, you may just want to have your buyer write down notes or write down questions that they want to ask about the property. There's certain things you may want to discuss, but definitely don't discuss anything about offers or how the house smells or the type of pictures that are up or family photos or how nasty the carpet may be. You don't want to do that kind of stuff anymore. Too many people can hear you and see you. And so it could really, really damage a negotiation if, for some reason, the seller was able to surveil and see what you were saying and hear what you were saying. So just, if you want to talk about it, if you want to talk about offers and stuff like that, let's go outside, go to your favorite restaurant, talk about the property, talk about the offer, and then you can talk freely then. But don't talk about it inside the property whatsoever. Hope that explains that. Let's finish up. So the last section here says this is a legally binding agreement. Buyer shall seek further assistance if the contents are not understood. Meaning, go seek legal advice. Go talk to the broker in charge if the agent's not able to explain it properly. The buyer and broker acknowledges receipt of a copy of this agreement and a copy of the South Carolina Disclosure of Real Estate Brokerage Relationships form. There it is again. And the buyer agrees to receive communications from broker at the email address, phone, and fax number listed below. Okay? So make sure you have proper information, especially the telephone number, because if you as the agent, something were to happen to you, the broker needs to pick right up on this. I include myself in that, we need to make sure that we can get any agreements that we have in-house and be able to contact that person. God forbid you got sick or we weren't able to get a hold of you. So make sure you have all the information available possible and let the buyer sign date and time and then their address, and then you sign for the company, you tell the company name, and you put your signature and date and time there on this page. Very self-explanatory. Again, make sure that you initial the bottom of page 4. Have your buyers initial the bottom of page 4. There's a whole lot of controversy. Why should initials be on the same page as a signing page? You know what? I'm not going to get into that. I'm not an attorney. They did this for a reason. So let's just go ahead. If you don't have initials there, please make sure that you get initials on the contracts. And then let's go with my ending disclaimer. So again, I really appreciate you taking the time to go throughout this, what we call the buyer's agency agreement or the exclusive right to buy video. I thank you for your time as always, but let me just stop and end with this. Remember, I've told you multiple times, I'm not an attorney. I'm only a broker in charge. And the South Carolina Association of Realtors does not endorse me doing this whatsoever. They have nothing to do with this. This is strictly done for agents of Berkshire Hathaway Home Services, seat and joiner realtors to gain a benefit of understanding these contracts. Now, this is obviously going out on YouTube, and other people from outside this brokerage are watching this video. I understand that. And when I said in the beginning of the video, you work for another broker. Please, if you have any questions about anything I said, please go to your broker and ask them exactly how they want this filled out, especially Section 5, the compensation section. Again, I have a different opinion than a lot of other people, so just get their opinion on how they want you to fill that out. Also including the retainer fees and service fees. There's a lot of things that our brokerage doesn't do that other brokerages may do. So again, it's not a one-size-fits-all. Just check with your broker. And if it helps you, I hope that it has. And please leave a comment below. And I look forward to seeing you around the Real Estate Corner. Take care.